Hello, everybody. Thank you for joining us today. We have a very exciting webinar. It's going to be a short one. We're going to do 30 minutes talking about the new CEO pay ratio rule as proposed by the SEC that they released last week on Wednesday. I know there's been a lot of interest. This is something we sent out invites on Thursday, and we certainly had a very large response in a short amount of time for people who are interested in listening. So we're going to go through it. We got not a lot of time, but a lot of information to cover. I'm proud to be joined by Jim Barrall, a partner at Latham Watkins, who, Jim, I would probably say the foremost written expert on this subject over the last few days. Would you agree with that, Jim?
I wouldn't agree with that, no.
All right. Well, you've certainly written a lot about it, and you wrote a piece for the Wall Street Journal that came out on Wednesday, which I thought was very good. And then you just came out with a piece for the conference board written about the 5 things that people should know about the new Dodd-Frank rule on CEO pay ratio. So I definitely suggest everybody to check that out, and I know we'll talk about that once we get going today.
Sure.
Just to let everybody know, you can download the slides from our resource center. We also have a neat little infographic showing you the timeline of some of the other proposed rules and when they've been enacted and were accepted by the SEC and put in place. We also have a quick summary of the Dodd-Frank, the new Dodd-Frank bill on the CEO pay ratio, which outlines some of what we're going to be talking about today and gives you a summary of what's going on, as well as some of the other rules that they have already introduced, and then some of the rules that they will be looking to introduce to finalize and complete the rest of the Dodd-Frank as far as compensation rules go. I would also like to recommend that later this week, for those who are interested, we are having a webinar on board pay that I would certainly suggest people to register for. That will be, I think, of a lot of interest to other people. Not related on to the CEO pay ratio rule, but nonetheless interesting as we talk about sort of the other side, going from CEO pay to director pay. So with all that said, let's just jump right into it. Today we're going to talk about the CEO pay ratio rule that came out, give a little bit of background, and then talk about what the rule actually says, look at some of the nuances of it, and then we'll talk about some of the implications as far as what it means for companies and how companies can potentially disclose it. So to go right into it, we have a couple key milestones I wanted to point out and just sort of show you the timeline of all this. Again, the CEO pay ratio rule, part of the Dodd-Frank, was really a very short sort of thrown in at the last minute provision on the bill. It was marked up in one of the committees, and it was not something that there was a lot of debate on, but ultimately got passed and was signed into law on July 21st, 2010. So that being over 3 years ago, the fact that we're just now getting to a proposed rule tells you how much there's been and how much work the SEC has had to do, not just on the Dodd-Frank rule, but on a number of other things. You can see that the say-on-pay rule was enacted shortly thereafter. It was proposed on October 18th. In December 15th, 2010, there was the conflict mineral rules, which were proposed. And that's of particular note because you can see as you go through, they then adopted the say-on-pay rule the following January in 2011, but it took them until the summer of 2012 and August 22nd to actually adopt the conflict of mineral rules. The conflict of mineral rules was a lot of people had a lot of things to say about it. There was a lot of concern about how difficult and cumbersome it would be on companies to be able to get this information. A lot of things very similar to the CEO pay ratio rule about it being maybe more work than it was worth. And you can see it took them 2 years to go from proposal to adoption. And so now that we have the pay ratio rule that was proposed on September 18th, and they had mentioned that they had received, Jim, I think it was, 60,000 comments, 22,000 comments?
I think 22,000, more than 22,000 comments with more than 88,000 signatures, and that was just based on the enactment of the statute in advance of any rules.
Right. So you can see that they had a lot to get through just before they even proposed the rule, and of course there's I think something about 160 requests for comment in the current proposal that the SEC is asking for. So you can imagine there's just a lot that's going to be debated about, and we're going to talk a little bit about comment letters and what people are going to say about the CEO pay ratio rule. So let's jump into this now. Let's talk about the rule itself and what they actually came out with. There was one of the complaints was that in the actual bill, in the law, it was very narrowly written, and so it didn't allow for a lot of flexibility for the SEC to interpret the rules and to give companies the flexibility to put it in place. And so there's a lot of concern that it would be pretty restrictive. But what they eventually basically came out with was saying, as expected, that they would require issuers to disclose the annual total compensation of their median employee, their chief executive, and to present the ratio between the two. So it seems like a pretty straightforward piece of disclosure that companies are going to have to give, but obviously there's a lot more to it than that.
And let me jump in on that, Aaron, just for a sec. You mentioned the conference board blog posted this morning where I posted on the 5 things that companies should do. That includes a link to the Latham and Watkins corporate governance alert that describes the rules in pretty good detail, number 1. And number 2 has a link to the opinion that I did for the CFO report, Wall Street Journal, last week in advance of the rules coming out the night before, basically making the points that you're making now, that the statute was very, very poorly drafted, thrown together. Not even the people who support it, except for one particular senator, think it does the job that they intended to do. They would love to amend it, but in this Congress, given that some people would rather repeal it, not make it workable, nothing's going to happen. So if you look at the CFO piece, you'll see exactly what the problems with the statutes are, and then you'll be able to appreciate as we go through this how much flexibility the SEC staff and SEC have already built into the rules in the proposed rules, and frankly, there's room for them to even do more, as they've indicated a willingness to do. So that's just a little editorial comment at the beginning.
Thanks for bringing that up. I mean, certainly I think a lot of people were surprised with the amount of flexibility, and we'll get into that in just a few seconds, the amount of flexibility that was built in to the proposed regulations already. But as you mentioned, obviously there's a call by companies to do more. So let's look at some of the specifics here and I'll ask Jim his opinion about some of these things. But looking at the pay ratio and what's in the proposed rules, looking at the calculation guidelines. Some interesting things put in there. First of all, they are allowing statistical sampling to be done. So obviously for companies with a large number of employees, there is discussion that there will be an allowance to use a statistical sampling instead of having to go through and get every single employee's information.
And that's very, very important because we thought, some people reading the statute literally thought you'd have to do the summary compensation table definition applied to every single employee in the world, do that calculation, then find the exact median. These rules are very flexible in that regard. They allow companies to use statistical sampling methods, and they go through some detail on what kinds of things can be done to identify the median employee, allow you to throw out the highs and the lows, allow you to use flexible definitions of compensation like base comp, not all in summary comp table. A lot of details there and a lot of room for companies to comment as to how they can live with those rules or not.
Yeah, so if we look into, speaking of employees, well, who are we including? If it said very specifically in the rule, all employees. There was a big concern about, do you have to include everybody? And basically the short answer to that is yes, you have to include everybody, but it's everybody as of the fiscal year end. And we'll get into that in a little bit later as we talk about potential issues with seasonality and part-time, but you do have to include foreign employees, you have to include part-time employees, and you have to include seasonal employees. So this isn't a situation where you can only include the full-time people that have been working at your company. And if you keep going, we look at it when you're talking about calculating the pay for these people. You can annualize the compensation for your permanent employees if they joined in during the year, and so you want to annualize that. But you're not allowed to adjust in low-cost jurisdictions, nor are you allowed to annualize a part-time employee salary. So if you hire somebody and they only work 20 hours a week, you can't say, well, if they worked 40 hours a week, here's how much we would have paid them, and use that as a number. Instead, you have to use what they actually earned.
And that would have the impact generally of skewing the ratio for the median employee down and the CEO ratio up. That people are guessing, although there's no one answer that fits all companies, but I think that's likely to be the impact of that particular rule if it stands.
Yeah, and it's I think there's obviously a lot of concern now. We've yet to see exactly what this will look like, and I think once companies have to start actually disclosing this, we'll see what the results are. But right now, there's just a lot of guesswork, and I think there obviously is that concern where if you're not adjusting for low-cost jurisdictions, so for example, if you have low-paid workers outside the U.S. where the cost of living is a lot lower, and so the wages would be lower than what they are in the U.S., but are still maybe commensurate to the cost of living, you are not allowed to adjust to that. So obviously a company that has a lot of overseas workers runs the risk of having a lower median number for their all employees as opposed to their CEO. And so if we look at the disclosure guidelines here, as far as what a company will actually how they have to disclose it, you've got the disclosure will be required beginning the first fiscal year on or after the effective date of the SEC's final rule, which we don't have the effective date yet. And Jim, do you have any guidance on?
Sure. That's a very, very important point, Aaron. The SEC, again, has been, I think, fairly generous in this area in giving companies time to respond. There's a 60-day comment period. The rule cannot be finalized within that 60-day period. I fully suspect the SEC is going to get many, many thousands of comments, very detailed comments on very detailed rules, which will take them a long time to study. I don't think that the rules will be finalized in 2013. The examples on effective dates in the rules focus on a 2014 effective date, signaling that that's what they suspect is likely to happen. I think that is very likely to happen. So 2014, if the rules become effective then the way the effective date statute works is the rule then applies to the first fiscal year of a company starting after that date. So if we have a calendar year company, that would be January 1 of 2015 if the rule is declared effective in 2014. And then that gives companies that year, 2015, the opportunity to gather all this information, analyze all this information, and then disclose it for the first time, not in 2015, but in 2016. So the first disclosure is most likely that for calendar year companies is going to be 2016 disclosure, and companies are going to have a considerable amount of time to comment on the proposed rules, number one, and then number two, to react and implement systems to deal with the final rule.
So just to make sure that I'm clear in terms of what we could potentially be looking at is if the SEC pushes the effective date until sometime next year, we might not see this start showing up for annual disclosure in calendar year companies until 2016. Is that right?
Correct.
So that's certainly a lot more.
Yeah.
It doesn't mean
I think this means.
Go ahead, Jim.
I was going to say, yeah, I think this means that companies don't need to start drafting stuff now by any means. I think the most fruitful thing for companies to do is to read the rules and then comment, because the SEC in its 162 pages of proposed rules and commentary really was honest in indicating problems with the statute from the very beginning, that there's no discernible purpose essentially. Nobody proved that there were, the problems of the last recession were caused by CEO pay ratios. Nobody has put together the case as to what the benefits of this statute are. So that's an open issue there. And then there are just a lot of costs, and the SEC has asked companies to comment, and there's 69 different specific comment requests, many with many subparts, and probably adds up to 150 or so, asking for guidance. And I think the SEC intends to consider those, and if companies come in and say, look, we're not going to argue with you about the purpose of the rule. We're not going to argue with the politics. We're just going to tell you that for us, even to use statistical sampling to find the median and compensated employee all over the world is not an easy thing to do for the following reasons, and we can talk more about the reasons. And I think the SEC would be sympathetic to that. So that's where I would put my emphasis, not in drafting disclosure now.
That's a great point. What I'd like to do is go through the last 3 points on this slide, and then get to some questions that people have been asking in the webinar. So for those who are attending, if you have a question, please feel free to submit it. I don't know if we'll be able to get to them, but I'd certainly like to be able to answer some of them. As far as the disclosure, what has to be disclosed, they said that you have to disclose in basically a brief overview, but you have to do it enough that readers can evaluate the appropriateness of the estimates, right, but not all technical details need to be provided. So basically the SEC is not asking for a long legal jargon written piece about CEO pay ratio rule. Jim, do you think we're going to see a lot of that, or is it going to be pretty simple and short?
Well, it depends how important people think this disclosure is and these rules are. My perspective is that investors don't really care about CEO pay ratios. They do care about a lot of compensation matters. They've proven that. They care about dilution. They care about pay for performance. They care about a lot of other things, but they don't care so much about CEO pay ratios. So it may be that that companies get a rule, hopefully that's livable, workable, flexible, and then simply disclose, and that's the end of the story. And a few companies will get called out in the in the New York Times, not the Wall Street Journal, but maybe the Wall Street Journal, but certainly the New York Times. And some CEOs will be embarrassed, and some companies may be shamed. I mean, that seems to be the purpose of these rules, is to name and shame. And if that's the case, then companies are not going to spend a huge amount of time. It's a number. It's one of many numbers. The numbers are going to be all over the place. It's going to be hard to compare numbers for various companies given how companies hire people, in what countries they hire them, how they pay them, all of that. So it could be that this doesn't mean very much. But if it gains traction, if it's like, say, on pay and people do care about it, then you'll probably see more disclosure. You'll probably see alternative disclosure. Say this is the CEO ratio calculated per the final rules, but we think it's really misleading. And we think it's important to our investors to know that it's misleading, and therefore we've recalculated it and we've thrown out we've taken all the part-timers and consolidated them into full-time equivalents. We've done this, we've done that, we've done the other things, and this is a more meaningful number. But I'm not sure that we're going to get there, because I don't really think investors care much about this now. But we'll see how this plays out. This could turn out to be like pay for performance disclosure when ISS came out and said you've got to use the summary comp table and et cetera, and that created huge backlash because that was important, and companies did get into a lot of disclosure, alternative disclosure, supplemental proxy filings. I'm not sure this is going to go that way, but nobody knows how this will play out over the next 2 years.
You bring up proxy advisors. What do you think their response is going to be to a pay ratio rule?
If I were a proxy advisor, I'd be very happy about the prospect of having rules like this. And the more complex, the better, because I frankly think the proxy advisors are in the business of selling their services, consulting and advisory, and I wouldn't be surprised to see them formulate policies and ratios and tests And in the same way they have for pay for performance, and say these people are outliers, and we're going to recommend no on their say on pay votes, and we're going to recommend against their directors. I think that's strictly for business reasons, not because it's particularly important to anybody, not because anybody really cares. Clearly people care about social inequality. People care about lack of opportunity and mobility in society. Those are all important things, but this CEO pay ratio disclosure does nothing about that stuff. So we'll see. What do you think? How's this going to play out?
It's here now. I think it's here now, and so what we got to do is obviously companies need to start preparing for it. One of the things that we're getting a lot of questions about who exactly to include as far as employees go. We talked about, well, you have to include all employees, and that includes both part-time, seasonal, temporary. People are talking with some questions, bringing some questions about what do you do with long-term leave of absence, and these sort of do you include contractors? Jim, as your best understanding, what type of employees are included in this rule, and which ones can you exclude?
I think you've covered the rule in the slides and in your commentary. Who is not covered are people who are not your employees. If you have outsourced employees, if you have leased employees, if you have independent contractors who are not employees, those are not employees. So those don't go into it. Otherwise, all employees come into the mix in determining the median employee. Now, that doesn't mean you have to do all the calculations to the nth degree, in summary comp table count for each of them, but they all come into the mix.
And that's one of the things about a median calculation is if you can sort of once you figure out who your population is, like we've already talked about, and I'm sure there will be some corner cases that will need to be handled specifically, but for the most part, people will be able to figure out sort of what group is going to be that median employees. I'd like to jump into some information and some data on the rest of the slides. We're sort of running out of time, and I feel like we need another good hour just to get through all the questions. But I do want to talk about the potential effects and what this could mean for companies as far as dealing with this situation. One of the things a study we've done here at Equilar is we've looked at the word count for CDNAs over the last 5 years, and you can see that the number's gone up quite a bit from just above 6,000 to over 7,000 words for your typical CDNA in the S&P 1500. And I think certainly a lot of it has to do with all the new regulations and the new requirements of disclosures. Companies are giving more and more information, and I think obviously with the inclusion of even a short piece on CEO pay ratio will certainly make this make the CDNA even longer for investors. And I think, obviously it's good for us here at Equilar because, we love disclosure, and the more information, the better. In fact, we're rolling out a tool to allow people to do keyword searches throughout the CDNA to find the useful information that they're looking for. But I think it is going to make it tougher for investors as they have even more information to digest. Is the audience for this really investors? Is that who's going to find this useful, or is this going to be are companies going to find this information useful at all?
My view on that is no. I think you're going to have so many numbers. Companies are organized in so many ways. The ratios will vary monstrously depending on whether the CEO gets paid $1, where the employees are, what currencies they're paid in. It's going to be a blooming, buzzing mass of confusion, and I just think that most investors are going to spend their precious time reviewing CDNAs and deciding how to vote, looking at other stuff. But that's not to say these things won't turn into political clubs.
Sure.
We shall see.
Let's look at some companies and some industries that potentially might be facing some issues here. If we look at Equilar did a study on CEO pay at the S&P 500 and looked at each industry, looking at how much the CEOs made. You can see that healthcare, industrial goods, and services were sort of 1, 2, 3, and all very close to each other. Obviously made the most. I think the takeaway from this particular slide, though, is for CEOs, especially in the S&P 500, they're all paid quite a bit. You don't have the variance where one industry is making $1 million and somebody else is making $20 million, but they're all sort of around the $9 million mark, except for maybe the utilities industry. But what I really want to highlight is we want to look at sort of point out 5 specific companies and the issues that they might have. And Jim, feel free to weigh in as far as kind of the difficulty that a company might struggle with. But you've got a company like Walmart, which obviously is the largest employer. They list 2.2 million associates working for them, and about 1.3 million of them are in the U.S. And so certainly they have an issue with just the sheer amount of size, and obviously a large majority of their people are minimum wage workers, and so I think there's an expectation that their number might not be great as far as the ratio is concerned. Berkshire Hathaway, on the other hand, they obviously have a large number of employees, and the majority of those are part of their subsidiaries. They have about, I think, 55 subsidiaries listed, and so even just gathering that information from all the different companies, I think will certainly be a hassle for them. So anybody who has subsidiaries, that especially a large number of subsidiaries, that could be a headache in terms of collecting the information. Then you've got a company like UPS, which go ahead, Jim.
And Aaron, that's an important point that we didn't touch on earlier. It's not just the company, it's subsidiaries, and the SEC adopted in the proposed rules a broad definition of subsidiaries. There's different definitions of subsidiaries. This is a broad one. So this is something the company should think about if they have subsidiaries. Now,
I'm going to jump quickly to IBM, which lists 434,000 employees. And they're interesting because they list in their number, what's included in that number is about 24,000 complementary employees, and then another 8,000 employees from less than wholly owned subsidiaries. So that's going to be, Jim, there's really not a lot of clarification in the bill about situations like that, but that's something that I think will need to be worked out as well, right?
Correct.
And so, obviously if they include those people, that can affect their number quite a bit. So depending on the corporate structure of a company, that can be quite the issue.
Yeah.
And then I just quickly want to point out UPS. Again, they're a company with a very high seasonality, and the 399,000 employees that they have listed, and that's taken from the 10K and how many employees that they say they have. They explicitly state that it excludes seasonal and temporary employees, which, according to this rule, would include. And obviously, UPS has a calendar year, fiscal year end, and they have a huge number of seasonal employees that only work for a short amount of time, and so they could be.
And usually at the holidays and on December 31, they're running up and down stairs.
So
they'll be included.
So according to you, if you've got UPS, their ratio could look drastically different at their fiscal year end than it would in, say, like a June time frame. And then you've got Goldman Sachs, which obviously has been maligned and sort of representative of the whole investment banking Wall Street group, but they only have 32,000 employees, and a large majority of them are obviously very highly paid. And so their ratio actually may end up looking a lot better than some of these other ones, even though there's been a lot of complaints. And I would imagine that the people who sort of first put this rule into place were considering Goldman Sachs and concerned about the levels that them and the rest of the financial services industry was making. They might end up looking actually a lot better than most of these other companies that we've mentioned, just because of the low number of employees they have and the high salaries for their regular employees. And just to hit the last slide, and then we'll get into some final questions here as we got wrapping up. I know we're just about out of time. You can see that the services industry has the most employees by far, and so I think they're going to be most affected by the number of by the CEO pay ratio rule. Is obviously a lot of those people in the services sector, whether it's people working for restaurants at minimum wage or working in retail outlets with seasonality, will certainly be lower the number for the median annual employee. And you can see at the bottom there, you've got the financial services, which has a median of about 1,600 employees, and this is looking at the S&P 1500, just to let you know the universe of companies here. And so you can see that the median number of employees, obviously, for the financial, much lower than it is for those at the services. And then you can see the industrial goods and consumer goods coming up second and third in the rankings. Seems like we're just about out of time, and I'd be remiss if I didn't, Jim. I feel like we need another hour just to go through all the intricacies of this. But what do you think is going to be the ultimate impact of this for companies, and what do you think that they need to do to get ready to be able to handle this?
Yeah. I think it's too early to judge the ultimate impact. I think it's fair to say that everybody agrees, 99% of people agree that the statute is a mess the way it was drafted. The SEC has tried to make the rules more flexible. Clearly the SEC wants to make them more flexible, but they need some input from companies explaining what the problems are. When they say you can use something like the W-2 to determine, the compensation for determining the median employee, in some countries they don't have W-2s. In some companies they have data privacy laws that prohibit the subsidiary from sharing the W-2 information. I think the SEC and the staff need to understand all of that, how that plays out. And I do think that the most urgent item, the most important item, is in the next 60 days for companies to look at the rules and ask themselves, if we had to live with this for next year, how would we go about it? What would it cost us? What would we have to do? And in my experience, many companies that are global, in particular with large numbers of employees, with many lines of business, do not have centralized databases. They don't have this information. And if you go to sell off a business that has worldwide parts, trust me, I've done it, it's hard to get information about how many employees there are in those countries, what plans cover them, what are their costs of their compensation, what do their employment agreements say. This is not easy to do, and I think the SEC would appreciate hearing all about that, and we might get some better rules. At the end of the day, I think we're going to have to learn to live with these rules, and then how much they matter to investors, how much disclosure is required, how much back and forth, and how important they become is really too early to tell. But I think the first item is to focus on filing comments either individually or through groups. There are groups that will be forming to file comments together. Even if you are part of a group, I recommend that companies file individual comments because numbers do matter. They do count the numbers. And if you file a comment and you simply say, we appreciate what the SEC has done, but it has not gone far enough for these 5 reasons, you don't have to write a book to get that out there and to get that on file and to have it be taken into account. And then, but to the extent you can be more granular about that, these are the problems we have, this is what it would cost, please, change this or change that or take this into account in the analysis, I think would all be very helpful. The one other thing we didn't say, Aaron, is that not all companies are covered by this, not all public companies. There are exclusions in the rules for the smaller reporting companies, those with, I think, less than $75 million of net worth. The foreign private issuers are not covered, and the emerging growth companies under the Jobs Act are not covered. That leaves about 4,000 companies covered, essentially the same ones that are subject to say on pay requirements.
Yeah, thank you. That's an excellent reminder too, because obviously I think as many people, especially the smaller companies who are obviously strapped with resources as it is, don't want to have to put more effort into gathering disclosure pieces like this than maybe they already have to. We've got just a slew of questions that have not had a chance to answer. I think a lot of questions are pertaining to the definition of the employees, who to include, who not to include. I think some of that will get clarified once the final rules come out. I think there will certainly be, as I would expect, a large number of webinars and white papers and studies and panels at conferences talking about this in the future, and I think people will get more clearance. I would definitely suggest talking to your counsel, somebody like Jim, obviously, who's an expert, and getting their advice on what you need to do. And I think even just preparing as far as like Jim said, figuring out what you need to do to be able to collect this information if the rule were to pass exactly as it is, and figure out what you need to put in place to be able to make something like this happen. I think it's also important to make sure that you're aware of the disclosure practices of what people are doing. Obviously it'll be incredibly useful once people do start disclosing this ratio, of looking at that number, seeing what people are writing, and remembering that this is included, and one of the pieces that came out was it only has to be included in the CDNA, so it's not something that potentially has to be included in the 10K or the 8K and some of the IPO filings that a lot of people were initially concerned that the way the rule was written, it may have to. But I think if people put it in their CDNA, remembering that the CDNA is part of explaining the compensation philosophy, and as we've seen as far as the evolution of the CDNA over the last 3, 4, 5 years, making sure that it does a good job of speaking to your investors and trying to give more of an explanation and giving more information than trying to go with the bare minimum. I think that we've seen that. Obviously, companies will need to make sure the lawyers approve of what's being written, but just remember that this is all part of a document that's going to your shareholders as they look to vote on the different items that will be at your annual meeting.
Aaron, one note. You mentioned webcasts, and there'll be a ton of them. I would be remiss if I didn't mention that Latham had previously scheduled a webcast many months ago, our annual webcast on compensation going into the end of this year and into the new year, and we will be covering some of this on Wednesday. We're doing that Wednesday. I think it's 10 Pacific, and if anybody wants to, they can send me an email or log on to our website and sign up if they want to do that.
Yeah, thanks, Jim. Again, I think it would be a good resource. Obviously, there's a lot of good stuff in the Resource Center for this webinar, including the slides, and of course we'll have a recording of this webinar available on the website after this. So everybody, I know this was short. I feel like maybe we should have to do another webinar just answering all the questions that people have, but we'll do the best we can to respond to every one of your questions that you have, whether or not we can answer them or not. We'll try and get to them. Again, thank you everybody again for taking the time today to sit in and listen. I know we probably didn't go over everything that everybody wanted to hear, but hopefully this was useful to you and to those who are just trying to get a new grasp on what came out on Wednesday and start to get a hold of what's going on and figure out what the next step should be. So thank you, everybody, for joining us today, and have a wonderful rest of the week.